My name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan, and today we're continuing our video series designed to educate and inform the public, so please subscribe to our channel. A lot of times people will ask me about false allegations in pleadings. They'll say, the lawsuit says that I hurt the kids, that I stole money. It's all a pack of lies, and my lawyer isn't doing anything about it. Well, you have to understand a couple things. First of all, unlike the natural inclination that every client, layperson may have, you don't try your case every time you open your mouth. You don't do that, okay? So the first time the lawyer gets in court, he's not likely to make a huge issue out of whether or not they said something accurate or inaccurate about you. Why? Because the lawyer's not going to reveal his hand so quickly. If there are outrageous statements made in the pleadings that are not borne out by the facts, it might be the strategy to hold off on saying anything. Wait till you come to a contested hearing or a trial. Then the lawyer can say to the person, oh, well, I see you're here today testifying under oath, right? Yes, I am. Well, I suppose you would like the court to believe what you say, right? Yes. Here's a statement, for example, that you gave before where you said your wife always took great care of the kids. Did you make that statement? Yes, I did. How come in your complaint you say that she neglected them? All of a sudden the person starts to look like they said certain things just to muddy the waters, but things that aren't true. In other words, your lawyer could be saving those things for later examination if need be. Once you start on the first meeting with the judge and you start making the issue of those items, you kind of take the steam out of your own case for using them later. You may need that thing. So number one, don't be upset if your lawyer doesn't try your case at the first proceeding, because it's not good strategy to do so. That's number one. Number two, there's a discovery phase. It is known by the court that people say all sorts of things about their soon-to-be ex. Some are true, some are not true. Some aren't lies, but they're a question of perspectives. I've never had a situation where somebody didn't walk in here and say, he abandoned us, and the guy says, what do you mean abandoned you? You threw me out. In other words, there's two sides to every coin. We live in a two-dimensional system. So there's always going to be one person saying one thing and the other person having a defense to it. I'm not so sure it's always about someone lying so much as it is a question of perspective. Your lawyer may feel the same way, or you may feel that the particular lie in question isn't overly significant to the overall case, and this ticky-tacky stuff doesn't help you. So for example, if the lawyer said that somebody, loaned a friend $800 and it was really $752, I don't think that that is a significant enough of a deviation to call somebody a lawyer and file motions about it. In other words, your lawyers have to figure out what's good evidence, what's not. What's good impeachment, what's not. So the strategy of how to use evidence is really something that you can talk to your lawyer about. You can bring it to his or her attention, but don't be offended if they choose to either not use it at all or use it later. You know why? Because they're experts in how to handle evidence and how to present cases, and you're not. That's why you hired them to do this for you. So have a little faith in the people that you hire. Don't expect them to try the case every single time they open their mouth. It'll make them look like amateurs and idiots. So don't expect them to do that. And if you let the system work, I'm sure it'll result in as favorable an outcome for you as possible. Now, if you have any questions about your specific case, reach out and we'll be glad to help you out.